everybody has a right. All those in power tend to limit the rights and freedoms of people. They always have, they do now, and this tendency will continue because by limiting people's rights it is easier to rule them and to accomplish political aims, even noble ones. But parliaments and governments are not free to do whatever they wish. They are restricted by constitutions and by international conventions which emerged after the Second World War, when the world realized how cruel even a democratically elected government can be towards its own citizens, and how it can be dangerous for citizens of other countries. Yet those in power fear public opinion. A citizen who knows and understands his rights, and who knows how to defend them, is no longer helpless. All people are born free and equal in their dignity and rights. This unalienable and innate dignity of an individual, whatever its religious or philosophical justification, provides the foundations from which identical sets of freedoms and rights arise. What are human rights? The rules of the game. In a colony which was part of a state ruled by law, the members of the colony granted themselves a monopoly over weighing salt. One day, 10 Indians came to the shore, sat down and began to weigh salt ostentatiously. They were soon arrested. The next day, 100 Indians began to weigh salt on the same shore. They were arrested too. However, when 1,000 people came to the shore the following day, the authorities had to give up the salt monopoly. In a state ruled by law, different treatment of persons who are doing the same thing was inconceivable. Of course, things would be different in a communist state. The police would attack the natives, 6 would be arrested and 4 set free for completely irrelevant reasons, and 2 more persons would be apprehended just in case, even though they never came to the shore. In a system of terror, the point was that whatever you were doing, you never were certain as to what would happen to you. That was the contradiction with the state ruled by law. The term state ruled by law, Rechtsstaat, was coined by the Germans. The rules of the game between citizens and state are clear, known to all and stable. The state is ruled by law and citizens can accurately anticipate the state's response to their actions. The clearer and more stable the rules, the better and safer are our lives. This is important for state functionaries too, as it protects them from arbitrariness of their superiors. Functionaries also have to act as suppliants at times. There are a variety of ways to defend oneself from infringement of one's rights by the authorities. The oldest instrument is the right of petition. It is more than simply the right to submit complaints. It also involves the authorities' duty to organize a system of supervision over their functionaries. The system, subordinated to the highest officials only, can be approached by citizens with complaints and examines all complaints submitted within statutory time limits, possibly also suggesting solutions. To a limited degree, the legal systems of communist states recognized indemnity. A person who suffered material damage as a result of the unlawful actions of an official could claim indemnity. But communists argued, quite a noble opinion on the face of it, that moral injury could not be compensated with money. And the institution of compensation was duly removed from the legal system. Thus, they owed nothing to a person they humiliated, to a person whose dignity they trampled and whose fundamental rights and freedoms they violated. The most effective way of controlling officials is to introduce direct financial responsibility on the part of an official and their office for infringement of citizens' rights. Everywhere it happens that officials infringe people's rights, but in a state ruled by law, the injured party is due indemnity paid solely by the official and their office. This is not at all unusual. This system has been tested and works in all states ruled by law. This reversion to the wallet has proved to be the only truly effective way of limiting the arbitrariness of functionaries. Administrative authorities decide on matters affecting citizens, but they have their own interests. Their decisions are sometimes opportunistic and their interpretations infringe civil rights. This creates the need for supervision over precisely this sphere, over the activity of the administration. This function is currently performed by administrative courts, which review only procedures, checking for observance of procedural law and looking for possible infringements of the law incurred during the passage of administrative decisions. What they do not review, however, is the substantive correctness, suitability and utility of the decision itself. For this reason, citizens sometimes fail to understand the purpose of these courts. So-called discretionary powers of the administration are submitted to judicial review in cases where the process of settling matters is left to administrative discretion by legislators. Here, judicial review addresses the motives of the administrations. If the grounds for a decision are found to be superfluous or unclear, that decision is quashed by the court as defective. The countries of Central and Eastern Europe are rather late in introducing judicial review over the administration. Once introduced, however, the review is gradually extended to a variety of administrative decisions and actions. Today, in countries where such review has been introduced, acts such as misleading a citizen or dismissing established employees without providing adequate grounds are submitted to judicial review. This way, the administration's motives are forced out into the open and have to be made generally known in order for citizens to be protected against the temptations of opportunism and distortions related to the current politics of a succession of cabinets. Judicial protection of citizens from the activities of the administration hails from the very essence of courts. The courts are the third power and as such are obliged not only to adjudicate individual disputes between citizens, but also to review and balance the remaining two powers, the legislative and executive. As a consequence, courts can also refuse to apply in concrete cases any statutes or other provisions which they find unconstitutional. This way, the courts are guardians of the citizens' constitutional position. The courts are separate from the administration and are independent. The independence of the judiciary is protected by a complex system of appointing judges, by their irremovability and immunity, by a ban on their conducting political activity, and by a tangle of procedural and organizational guarantees relating to the work of the court. The purpose of all of this is to make the courts independent from the administration. One's viewpoint depends on one's position, and the court's view of reality is basically different from that of the public prosecutor, the administration, or the police. The point here is that a citizen brought before a court must feel that he has been placed before the authority of an independent agency. No protection of rights and fundamental freedoms is possible without the right to a fair trial. That is guaranteed by a regular court of law, not one that has been specially appointed by those in power to sentence political opposition in a concrete case. The court must examine cases promptly, so that the temporary relationship between the act and the decision is not ended. The court also must be staffed by persons whose legal knowledge as well as moral standards and honesty raise no doubts whatsoever. An important element of protecting human rights and freedoms is the institution of the Commissioner for Civil Rights Protection, the Ombudsman, which originates from the 18th century Sweden. After the Second World War, that institution spread through and beyond Europe. The office of the Commissioner is not contained in the classical tripartite separation of powers. It is not an element of that separation and indeed does not exercise any power. The Ombudsman, or Commissioner for Civil Rights Protection, is usually dependent on Parliament, from which he derives his independence. He sometimes enjoys immunity and cannot be brought before the court during his terms in office. It is his task to point to cases of infringements of civil as well as human rights. The Ombudsman expresses doubts as to particular cases and may also, this is the procedure adopted in Poland, initiate cases before the Constitutional Tribunal, challenging the legality and constitutionality of statutes and other legal provisions. Also, he may initiate changes in the practices that violate the rights of citizens. The Ombudsman is not an agency that redresses damages or settles matters. From among the cases submitted to him, he chooses those which seem particularly important because they represent a large group of persons or involve an extremely painful injury. If the Ombudsman attempted to address all cases, would soon develop a particularized log of suggestions and complaints, and his work would be ineffective. The people who approach the Ombudsman must be made aware of the fact that he is not an influential confederate willing to support the interests which the citizen would like him to support. The Ombudsman only acts in defense of citizens' rights and position, for this reason, will not become involved in disputes between neighbors, for example. But the Ombudsman is also a specific type of teacher. Other authorities, the administration in particular, how to apply a pro-citizen interpretation of the law and how to be free of arbitrariness in their activity. Each person plays many social roles in his lifetime. Each person has specific traits which put him among a minority in particular life situations. Persons sharing such traits unite in defense against a majority which is indifferent to their problems. We can also prevent our rights from being infringed. In countries with a long democratic tradition, many non-government organizations operate within the sphere of social life. In mature democracies, non-government organizations are able to have bad laws squashed. They change the mentality and social reality. They do not aspire to power and do not want to take part in it for its own sake. This is the fundamental difference between such organizations and political parties. Non-government organizations protect those specific rights we need in order to perform our particular social roles with dignity. The network of such organizations is a special protective tissue separating each individual citizen from anonymous majority rule. There are many ways through which a citizen may defend himself against infringements of his rights by those in power. Constitutional, administrative, civil and criminal courts, direct application of the Constitution and liability of civil servants, the legislative initiative of citizens and referendum, the office of the Ombudsman and the institution of the petition. This is not even the whole catalogue of means of defense. Having exhausted all the possibilities within the state, the citizen can also approach the International Human Rights Court, which may decide whether his state was correct in doing what it did to him. Communist states violated the rights of their citizens and argued that it was their own internal matter. It is not true. There is a specific sphere where the sovereignty of the state is limited, where the international community may intervene in internal matters of an independent state. That sphere is the protection of the rights of individual people, of each and every one of us.